Hey guys, it's Jennifer with Purple for Parents Indiana, and I'm going to take a few minutes here to explain Indiana Senate Bill 288. We had an amazing accomplishment this week. On Wednesday, this bill passed out of the Education Committee in the Indiana Senate. On Monday, it will get a vote from the Senate floor, and Purple for Parents Indiana is fully supporting this bill, and I want to explain why. So this bill removes the exemption that allows public libraries and schools to distribute obscene and pornographic material to minors. I know what you're thinking. How is this even an exemption? But unfortunately, it is. And I don't think a lot of people realize that it is, or a lot of people recently may be confused about what this means because the opposition is trying to blur the lines and muddy the waters and confuse people on what exactly we are trying to accomplish. So hang in there and we will explain it. So Indiana Code 354913 states, so this is already a law in Indiana, that a matter or performance is obscene if the average person applying contemporary community standards finds that the dominant theme of the matter or performance taken as a whole appeals to the prurient interest in sex, the matter or performance depicts or describes in a patently offensive way sexual conduct, and the matter or performance taken as a whole lacks serious literary, artistic, political, or scientific value. Okay, so that is defined as matter or performance that is obscene. Okay, Indiana Code 354922. Matter or performance is harmful to minors if it describes or represents in any form nudity, sexual conduct, sexual excitement, or sadomasochistic abuse. Considered as a whole, it appeals to the prurient interest in sex of minors. It is patently offensive to prevailing standards in the adult community as a whole with respect to what is suitable matter for or performance before minors, and considered as a whole, it lacks serious literary, artistic, political, or scientific value for minors. I think what is really important with all of that is that obscenity is defined in our law. It is defined in our code. And the opposition to this bill is trying to act like it is going to spill over into areas that it is not. Okay? I want people to understand that if you provide materials that are defined within those codes to a minor outside of a public school or a public library, you will be arrested. All right, so let's talk about the exemption that SB 288 is attempting and hopefully going to rid of in our law. The exemption is Indiana Code 354934, and it is a defense to prosecution for dissemination of matter or conducting performance harmful to minors. So what we just read, this exemption gives a defense to public schools, kindergarten through 12th grade, if they use anything within those definitions that we just read, or public libraries. Why? Why do we need an exemption for public schools, kindergarten through 12th grade, which is minors, okay, or public libraries to provide for minors the information matter that would fall within the definitions that we that I just read to you on the two screens before? As we go forward, I want you to understand and think about this. This is taxpayer funded. So these public schools and public libraries are using taxpayer money to provide material that falls within those definitions, that definition of obscenity and pornography, to minors. If you give those same things to a child outside of a school or a public library, it is illegal and you will be arrested. Okay, so this exemption exempts schools from that. And then, all right, so fine. They're exempted from it. Let's just pretend that it never happens, except that it does. It happens all the time. Facts to note. So here are some things that are important to know about this exemption. So obscenity is not protected under First Amendment rights to free speech, and violations of federal obscenity laws are criminal offenses. The opposition to this bill like to say, well, I'm worried about the First Amendment. But according to what is in the books and the Supreme Court, obscenity is not protected under First Amendment rights. So that is not a defense to not support this bill. States passed these exemption statutes in the 1970s. So this obscenity exemption was passed based on Alfred Kinsey's fraudulent data he documented after sexually tormenting and abusing children and babies. Kinsey, who was a pedophile and sadomasochist, concluded children are sexual from birth. They went on a tour of America at the time, once he came up with his data, and got states to put in their laws this exemption for public schools, public libraries. And the only reasonable explanation of that exemption, based on what his fraudulent data was, is because they want to sexualize children. So that's the only reason that we have the exemption on within our law. Okay, I wrote unintended consequences. Question mark. The reason I wrote that is because when we testified in support of this bill, the people that testified against this bill liked to talk about the unintended consequences. And I don't know, it was almost like they got in a huddle before they testified, and so they could all talk about unintended consequences. And the unintended consequences that they were talking about was, well, we're worried that the schools, the teachers, the librarians will get, prosecuted if they provide this material to minors. Well, guess what? That's how the world works. Okay, so just don't do it. Schools and libraries are government institutions that absolutely can put systems into place to stop this. So let's talk about a real unintended consequence. Okay, children who are exposed to pornography tend to engage in sexual acts at younger ages, resulting in increased STDs, unwanted pregnancy, and many other emotional consequences. That would be, I use very lightly, a real unintended consequences. When you're talking about an unintended consequence of pornography for minors, that adults might be held responsible for what they're doing. I mean, they are adults, so they need to take full responsibility for what they're doing. And really, that is not an excuse. Now, a child sitting in a classroom where a teacher reads a book that would be defined as obscene, does that child get to get up and walk out of the class? No, they'd be in trouble. Okay? They don't get that choice. They are a child. An adult has the choice to provide obscene material. So don't do it. It's pretty simple. Another excuse that they like to use is that there's already filters and laws in place. But let me tell you something, as someone that works in school and someone that had worked in the school and someone that has children. 100% this is true. Parents do not see every assignment, lesson, or book their children are exposed to at school. They don't. And if your child is in a school that has a reading counts program, and there's other ones, but I'm going to use reading counts because I am familiar with that one, and your child is a responsible child and they get done with their assignments and they use their time wisely, they can check out a book. And there are many obscene pornographic books in your child's school's library to read for their reading counts, quiz, test, grade for their, for their, what will be calculated into their overall grade. They can check that book out, leave it in their desk or locker or backpack, read it. You will never see that book. So for anybody to go in there and say, well, we already have things in place that a child or a parent can opt their children out of that, is lying, and they know that. They know that parents do not see everything. Finally, I want to make a point that when we testified for this bill, we were not allowed to read the obscenity that we found in the schools in our testimony because the Senate Education Committee was worried that children would hear it. However, these materials remain in our schools. I mean, that tells you everything you need to know. We were not allowed to read it because it was so offensive at the State Senate Education Committee. However, it is still in our schools, and your children are still being exposed to it, and I can actually prove it because I can pull up the books that we know of that are obscene and pornographic. I can pull them up on the school sites. And guess what? They say in the little corner, out, because they've been checked out by a child. So right now, a child is being exposed to it. How are they exposed? Again, they're being exposed through the books that are in the libraries of the school or the public library. And they're also being exposed through the databases that schools provide and libraries provide for children to do their research on. EBSCO, you have probably or may not have heard of EBSCO. They're consistently on the child exploitation, sexual exploitation organization's list of Dirty Dozen. This one was from 2017, but they have been on there every year since. And I just got a memo today that said that they will be on there for the 2021 Dirty Dozen list as well, which is going to come out in a week. So, but EBSCO provides the online databases that our schools here in Indiana use, like Inspire and Explora. Okay, so when your children do their online research, they're using a online data resource database that is consistently on the Dirty Dozen list for child sexual exploitation. Who objected to this bill? Okay, this is Mr. Tim McRoberts of the Indiana Association of School Principals. He is an associate executive director. There's his email if you would like it. In his testimony, he stated that he objected to this bill. One of the reasons was because he was worried about school plays. But Mr. McRoberts, if you have plays within a school of kindergarten through 12th grade of minors that fall within the defined by our law obscenity and pornographic matter or performances, we have bigger issues than we realized. Okay, here's Bob Swaney. He's a director at Carmel Clay Public Library, and he wanted us to know that he objected to the bill because parents can decide what they want their children to read, which I would tell Mr. Swaney that parents do not get to see everything a child gets to read, especially within the school. And he states very clearly that his library is on the campus of Carmel Clay High School and that they are direct partners with the high school and work directly with them and the students and children there. He also said that we didn't need this bill because the back cover of the books told you what was in it. And I have another video which I can put in the link a link below in the comments of this video, but I prove him wrong on that as well. Oh, yes. Indiana Library Federation, Lucinda Nord, executive director. She testified that there was already laws in place that would protect children from this, and that there were cases that she could point to that would show that there was no way this could happen. However, after her testimony, she was called out in the hallway and asked to provide some of those examples, and she couldn't provide one. And the reason she couldn't provide it is because it doesn't exist, because there is an exemption in the law, and so she lied as well. If you took a case with the exemption as it is to a prosecutor that my child received this book, it's pornographic, and they were able to check it out and read it, the prosecutor would say, oh, that's horrible. And if they were in the street outside of the library, I could prosecute. But since they were in the library, too bad. Yes. Here's another one. Indiana School Board Association, Lisa Tanzel. She's the attorney for them, and it's really concerning because she went in there and said, we don't need this. And one of her reasons was that she said back in 2018, Indiana passed a law that sex education in Indiana was an opt-in, so parents had to opt their children in to even receive that type of education, which that's not even what we're really talking about with this bill. And as an attorney, you would think she would know that. However, let's go back to what she said. She said it was an opt-in state. She's lying. It's an opt-out. And back in 2018, she even wrote an article about how it was an opt-out state. Unbelievable. Okay, so let's not forget the constant objectors of accountability, our teachers union. Yep, they also are objecting to this bill because that would make them accountable for something. Finally, I want to tell you that the argument in the testimony that we heard against this bill was, well, kids will be kids. They can get this material outside of school and library, and kids are going to find a way. Well, let me tell you something. To every single person that testified, to every union, including the ACLU that is now against this bill, which do we really want them to be our moral compass? Let me tell you something. You're right, kids will be kids, but it is not the government's institution's job to influence our children at the lowest denominator. So your job should be to uphold the highest standard and allow parents to deal with, life situations as they see fit. Because there are a lot of parents out there doing everything they can to protect their children from this just evil pornography, obscenity, material that is way over a child's understanding and comprehension. And we do not need the schools and libraries to overstep their bounds and take that responsibility and right away from us. So you should uphold the highest standard. Who supports this bill? Purple for Parents Indiana and many, many, many organizations who are trying to protect children, who are trying to protect morality, and millions of Hoosier parents and taxpayers. Please take action right now. This bill passed the committee and it will get a vote on Monday in the Senate. We need you to contact, call, email your senator and ask them to sign on to SB 288 and vote yes. Vote yes to protect these children from material that is harmful to them. If it is illegal on the street, it should be illegal in schools and libraries. Put our children first.